Let's talk about your five sort of problems with originalism. This is in terms of a methodology of approaching the Constitution. The first one is you call the epistemological problem. What is that?
We've already touched on it. So many people were involved in drafting, ratifying the Constitution. It's impossible to say there was an intent to be discovered. Even if we focus on original meaning, practices at the time varied. There's no reason to believe that what was done in 1787 or 1791 is what the framers meant to enshrine and protect for all time.
All right, so let's just be like, if we're looking at a law that is passed, right? I mean, I know the court does this. They're looking at they'll look at the Federal Register and they'll see what the debate was in the House and the Senate. And ostensibly, that's the way that you can glean the intent of Congress in passing a law. And your argument is we can't do that with the Constitution because they didn't keep the records in the same way, that it was too disparate. What is the, why can we do that for a law? And just let me just also preface this too. I can't help but think about Scalia in the Voting Rights Act case, the Shelby case, where he basically said this was their intent, but they were so afraid that's why they passed they reauthorized the Voting Rights Act. So but please, sorry, original question.
There's so much in the question. First, the conservative justices have rejected looking at legislative history when it comes to statutory questions. They've said when it comes to interpreting statutes, we shouldn't be looking at the congressional history, statements in the House and Senate reports, because that's all too invented and too inconclusive. So the same criticism that Justice Scalia has made about looking at legislative history in the statutory context applies here as well. Second, it's all of the problems that you identified. There was no transcript of what went on in the Constitutional Convention in 1787. James Madison took the notes, but they are very incomplete. Also, there's limited records went on in the state ratifying conventions. It's hard from this to say we know the original meaning. When I teach constitutional law, and I did this semester, I like to point to all of the places where Alexander Hamilton and James Madison disagreed about major questions. And if they, in hindsight, weren't in agreement, who are we going to say was the framer of the Constitution?
And to what extent do originalists move to become textualists, and how is it really in any way different? Because isn't a textualist really like an originalist who's interested in meaning as opposed to intent?
All justices start with the text of the Constitution. The problem is that the text rarely resolves any of the issues that come before the court. What's cruel and unusual punishment? The first case I ever argued in the Supreme Court about a man who was sentenced to 50 years to life in prison for stealing $153 with their videotapes. I argued it was cruel and unusual punishment. 5 justices rejected that. What's due process of law? What's liberty? What's free exercise of religion? How are these to be balanced against other interests? The text answers none of those questions.
Let's move on to the incoherence problem. What is the incoherence problem with originalism?
We touched on this too. If we want to be originalists, we should have to follow the framers' intent about how the Constitution should be interpreted. But the framers didn't want their intent to be controlling. There's a terrific article by Jeff Powell, a Duke law professor in the 1980s. I think it was titled The Original Understanding of Original Understanding. And he made a compelling case that the framers never imagined that their views would be controlling. Forrest Bitker, a Yale law professor, also wrote an excellent article for this. So if we're originalists, then doesn't originalism compel us to abandon originalism?
Okay, tease that out for me. When you say they didn't intend for their opinions to be controlling, that means that the framers, if we are to sort of like concede that we could identify who the framers were, exclude some, include others, that they never meant for their ideas about what they were writing necessarily to be the end all be all, that they were completely rigid about it. So, yeah, how does originalism, like, so then the original, if we are actually subscribing to the originalists' intent, their intent is that you should not be originalists, essentially, is what the argument is. But how do we know that they didn't contemplate their words to be controlling?
We, of course, don't know what they intended with regard to how courts should interpret the Constitution, because the power of courts to interpret the Constitution is never mentioned and it wasn't discussed. Now, the reality is they looked at jurisprudence so differently than we do today. They believed that there was a natural law that was out there and that would be mechanically applied by judges. No longer do people believe that. So it's very difficult to take their philosophy of judging and apply it to the 21st century. But in terms of how do we know, I'll go back to the words of John Marshall, where he said, it's a Constitution meant to be adapted and endure for ages to come. And John Marshall was one of the framers in Philadelphia in 1787.
The next problem you have is the abhorrence problem, which I think is a little bit more obvious to at least to my ears, and that is simply if you actually interpret the Constitution in the way that the originalists want, we would be living a horrible life.
Well, it would lead to constitutional jurisprudence that few, if any, of us would want. Under originalism, Brown versus Board of Education was wrongly decided. The same Congress that ratified the 14th Amendment voted to segregate the District of Columbia public schools. There's simply no evidence that Congress meant, in proposing and ratifying the 14th Amendment, to outlaw segregation. Under originalism, Loving versus Virginia was wrongly decided. Loving was the 1967 case that said that states cannot prohibit interracial marriage. Most states prohibited interracial marriage in 1868. California had a law that prohibited interracial marriage till 1948. As recently as 1967, when Loving was decided, 16 states still prohibited interracial marriage. Or take the Constitution's prohibition of sex discrimination or sexual orientation or gender identity discrimination. Justice Scalia was fond of saying there is no constitutional prohibition of sex discrimination because the framers of the 14th Amendment, the Equal Protection Clause, were just focused on race. I would say any theory that makes Brown and Loving and a prohibition of sex discrimination illegitimate has to be one we reject.
In fact, Scalia referred to himself as a faint-hearted originalist. And to me, that gives away the game, right? Because the whole point of originalism is that this is a static document that we can divine the meaning of it because it exists completely separate from outcomes or context or anything. It was enshrined, and it's just a matter of like wiping the dust off of the tablets that it was imprinted upon. How can you be a faint-hearted one of those? That to me seems to be an incredible contradiction and an admission that we really can't do it this way, or we're going to have a horrible country.
I, of course, agree with everything that you just said. Let me try to put Justice Scalia's comment in context. Justice Thomas has said repeatedly that precedent should deserve no weight in constitutional law, and all prior decisions inconsistent with originalism should be overruled. And Justice Thomas has said this on many occasions. And countless decisions would have to be overruled by the Supreme Court if it was to be originalist. For example, no longer would the Bill of Rights apply to state and local governments. Justice Scalia, in response to that, said, I don't want to overrule all of those prior decisions, and it led him to say, I'm a faint-hearted originalist.